Hello, I'm Karen and welcome to this presentation of updating your will if you're getting divorced or separating. We'll cover some of the reasons you may want to do this now and answer some common questions. We're looking at a very specific window of time. This is the moment where you are still legally married but not together. You may have just formally filed your divorce petition or informally separated your households and finances. This window of time could last 3 months or even decades. It's possible for people to die during this specific window of time, and what happens to their assets may not be what they intended. The key concept is that this is a period where you are legally married, and with that comes some built-in assumptions the law makes for you. When someone has not planned in advance, the laws of your state make some decisions for you. This includes who gets first priority to be your executor of your estate if you die, who inherits from you, who can consent to medical procedures if you are not able to do so yourself, who can make final arrangements, and so on and so forth. Your first steps might be reviewing any estate planning documents you currently have with an experienced estate planning attorney. And if you don't have any documents, it might involve contacting an attorney to discuss what happens without advanced planning. You should discuss with your divorce attorney if there are any prohibitions on changing your estate plans or other agreements that prevent you from doing so. For example, when you file for divorce in some states, the court will issue automatic temporary orders preventing you from assigning your life insurance policy to someone else. You may need to get a court order or a signature from your spouse to do so before you are divorced. If it is safe to do so, you could also have an open conversation with your soon-to-be ex and explain that if something happened to you between now and the time you're divorced, you'd like so-and-so to be your decision maker, for example, and your spouse might want to do the same thing. You might want to update your will during this window of time. A will is a document you prepare to identify an executor. Please watch some of my other videos for more information about who this person is. The will says who inherits from you. The will identifies a guardian for your minor children if the other parent is unavailable or unwilling. The will has certain formalities to be properly executed as determined by your state's laws. Should you update your will if you're married but about to be divorced? If you are certain you want someone other than your spouse to be your executor, you may want to do this. If you want to make sure your spouse doesn't inherit your share of the assets, you may want to do this. A word of caution. Your attorney should draft your documents correctly identifying your current marital status and identify your spouse by name. Your state may have an omitted spouse statute, so consult with an attorney in your jurisdiction to ensure your wishes are properly expressed. You may want to update your powers of attorney. A power of attorney, sometimes called a POA, is a document that appoints someone else to act on your behalf if you become incapacitated. The healthcare POA designates an agent for healthcare and medical decisions. The financial POA identifies your decision maker for finances. Without these documents, your spouse typically has first priority. But what if you don't want your spouse to make these decisions for you anymore? What if your spouse declines to do so and you haven't named any backups? Bear in mind that some POAs include a paragraph that removes the spouse from the priority list if a petition for divorce has been filed with the court. Have your estate planning attorney review your POA with you. Should you update your POA? If you know you don't want your spouse making decisions for you during this window of time, you may need to update your POA. Let's turn to some common questions. Do you need a lawyer? There's no requirement that you hire an attorney. Plenty of people write their own wills. If you have a cooperative family member and a cooperative soon-to-be ex, things might just end up okay. However, if you do not have involved people who will work it out peacefully if there's some type of dispute, then it might be a good idea to hire an attorney to help. We've seen plenty of expensive probates where people are accidentally disinherited and there's confusion about who gets what and under what circumstances. We also see documents that people thought were official and weren't because they didn't know that they had inadvertently invalidated their documents. Each state has its own rules. What if you don't know even what you own at this time? This will depend on your state's laws. You may not know what is ultimately going to be in your pile from your combined marital estate. You can only give away what is yours, though. If you write a new will that gives your share, whatever that ends up being, to your kids, and you make your sister the trustee, that means that once your individual assets or percentage of the estate is determined, those assets will pass to your kids rather than your spouse. What happens if I die before I'm divorced? Well, this is the big question. If you have no will, you'll look to your state's intestacy laws. Intestacy laws specify who inherits when you have not planned in advance through a will or a trust. If you do have a will or trust, then look to that instrument. You may also need to consult with any signed property settlement agreement or other agreements or court orders that are in effect at the time. Can you still include your soon-to-be ex-spouse in your estate plan? The answer is yes. I have seen people who need to get divorced for whatever reason, but they still see their ex-spouse as their number one go-to person. They still trust them with their decision-making, and they want them to inherit. They may still want them to be trustee of any children's trust. If this sounds like you, it might be a good idea to draft a new will, restating your choice so your family or other heirs have less ability to question and dispute this choice. Well, that's a short presentation of updating your will if you're getting divorced or separating. Thanks for watching. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Thank you and bye for now.